The U.S. Supreme Court is hearing two of the biggest cases of the year. They could determine the future of race-based affirmative action in higher education across America. A conservative advocacy group is asking the justices to issue a blanket ban on the consideration of race in college admissions. And ABC News is learning today two attorneys who have represented former President Trump will join in making that case against affirmative action during oral arguments. So what kind of impact could this ruling have? ABC News Supreme Court contributor and law professor at Cardozo School of Law, Kate Shaw, is here to break it down for us. Kate, thanks for being on. The court appears poised to roll back the use of race in college admissions, at least somewhat. Arguments against affirmative action started, saying that it contradicts the Constitution's guarantee of equal treatment. So what precedent are these arguments resting on, and what considerations do the justices have to take into account here?
Well, Diane, the arguments started at 10 o'clock this morning, actually with the challengers invoking the 1954 decision Brown versus Board of Education, which of course held that the Constitution and its equality guarantees prohibit segregated public schools. So these challengers argue that Brown basically requires race blindness in education from elementary through higher education, and that universities that use race even as part of a holistic analysis of whether an applicant should be admitted, are acting in a way that is incompatible with the equality guarantees of the Constitution, and that the Constitution actually requires race blindness in college admissions. So it's a big, bold argument that's actually quite inconsistent with the Supreme Court's cases on how and when race may be used in admissions and college education, in college admissions. But of course, this court is a very different Supreme Court than the court that has considered previous such challenges.
Now, advocates have said that taking race into account helps to boost diversity on campuses, which helps everyone on campus. Does that work as a legal argument?
The Supreme Court has accepted it before, Diane. So in 2003, that's the last big Supreme Court affirmative action case. The court took a look at two different affirmative action programs, one of which basically used a point system to give members of underrepresented minorities points, basically in admissions, and the other one of which looked at applicants in a holistic manner, considering race in addition to all kinds of other personal and family characteristics. And what the Supreme Court said there was that actually quotas or point systems are impermissible under the Constitution, but that a holistic consideration of race is permissible because it's basically driven by universities' desire to create diverse learning environments, and that kind of sort of quest for diversity in education is a compelling government interest, that it's good for everyone to learn in a diverse environment. And it's important to train individuals from all backgrounds to ascend to the kind of highest levels of government and business and the military, and essentially for our kind of governing institutions to reflect the diversity of the country. The court has said that all of that is important and permissible, but all of that is, I think, in question today.
All right, we're going to be watching that case closely. Kate Shaw, we appreciate it as always. Thank you.
Thank you, Diane.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.